Thank you for joining us. Lukas and Cynthia here with Hometown Hero. Today we're going to discuss the Arkansas lawsuit and all of the details around it. Okay, Cynthia, catch me up on, I guess let's start from the beginning. Talk to me through the Arkansas lawsuit. Why did we get involved in this in the beginning?
So we got involved in this because, and I have to say thank you to you and really to the whole Hometown Hero team, because like I have never worked with anyone before that I'm like, can I just sue the state? And you're like, yeah, do it.
I feel like at this point, that's part of why we're here.
I know. And like, it's really, and it's so funny because people call and they like want information on lawsuits and should we do it? And like, we've become like this go-to on lawsuits, which I love. Yeah,
you've to your compliment, you've become very much an authority within this industry on the legislative side, on the regulatory side, on the legal side. I mean, the amount of calls that you get on a daily basis of people in a variety of different states saying, what do we do? And then you literally put together the strategy for them and hand it to them, and then they go subsequently win and make progress. It's pretty amazing. You know, I tell people, and I don't say it jokingly, this industry exists largely at this point because of you.
Oh, I don't know about that, but
I strongly believe that. And even within the capacity of us, what we do and the things that we facilitate would not happen without you. So on behalf of everybody, thank you for doing what you do. And give me details on the Arkansas thing. How did we even get involved in this?
This is the funnest thing ever. And by the way, Hometown Hero has a reputation. And I did talk to a state regulator one day who said he had told his entire team to be careful with me because we would sue them.
You've been served.
Oh, great. Right, thanks a lot, asshole.
I've been in meetings with you before where politicians have said, don't piss her off because she will sue you.
Did we lead the charge on this lawsuit? Because I know we're not the main plaintiff.
We're one of them.
Right.
We're one of the plaintiffs, and we, the charge that we had lobbyists in Arkansas, and it was because we had gotten a heads up about this really bad legislation. And Arkansas was very low on our list in terms of revenue, but it is a very close state to us. So
Correct.
We have to pay attention to what happens.
Arkansas can influence Texas
Correct.
legislation.
So we had to pay attention to it. And we had lobbyists working on our behalf, just kind of like keeping an eye on things. And then we got wind. There were two bills. One was like a 3-page regulation bill, which was fine. And then there was this other piece of crap, which got all the momentum. And so talking with our lobbyists, I was like, listen, if we're not going to, and so Arkansas is also like Texas in that they only have session every other year.
Okay.
So
are they same years as Texas, or are they opposing?
Same years.
Okay.
So if this thing...
So that means we've got a session in Texas coming up in 2025 and Arkansas.
Correct.
Okay.
So if the bill had been allowed to pass and just sit until the next legislative session, it would have been 2 years of this crappy bill. And you know, getting a legislative fix is not always easy, right? Sometimes it is easier to go to court.
So this bill passed in 2023?
It did. It passed.
Made it through legislative session. Governor signed off on it.
So just to show you how much support they had, and I'll give you some more backstory. So it was SB 358. It became Act 629 in April. On the Senate side, there were 30 yes votes, and then 4 other votes that were no or they abstained or something. Okay. On the House side, there were 82 yes votes, and then 18 that were either not there or they abstained or something.
Now, at the time, did Arkansas have a illicit marijuana industry?
They have a medical industry. Now, here's where it gets fun. So the prime company or the number one company in Arkansas is also the same company that now has a single monopoly. They're the only license holder in Louisiana, Good Day Farms. Okay, the guy who owns...
That doesn't sound like there's any issues there. What could go wrong?
What could go wrong?
Texas.
So we wanted to keep an eye on it because we were also fighting in Louisiana, where, by the way, there's going to be another lawsuit. Yeah. Because they did stupid things. But anyway, so Arkansas was not high on our list of revenue, but it was so close to Texas, and it was so bad. I mean, this is pages. All the yellow is all the stuff that's...
Give me some highlights of this and sort of what they were trying to do.
So what they were trying to do...
Or what they actually passed.
Well, here.
Because this all passed, correct?
Yes.
This is the definition of the bill. To prohibit industrial hemp that contains certain delta tetrahydrocannabinol substances, to include certain tetrahydrocannabinol in the list of Schedule 6 controlled substances, and to declare an emergency. All caps. Wow.
To declare an emergency? What does that mean?
Yeah,
you know, there's a public health emergency.
It literally says to declare an emergency.
Because
also, what's Schedule 6?
that's their state controlled substances.
Okay. So it's like their Schedule 1 federal.
Yeah. So basically what they wanted to do was obliterate it and only leave growing.
Yeah, it says right here, it is the intent of the General Assembly to prohibit the production and sale of intoxicating substances derived from industrial hemp. Okay, so the first comment, this isn't the actual bill wording, but there's a comment about it. This revision effectively redefines, quote, industrial hemp to instead say industrial hemp means the plant cannabis sativa in any part of the plant, including the seeds of the plant and all derivatives, extracts, cannabinoids, isomers, acid salts, and salts of isomers, which is taken from the Farm Bill, whether growing or not, with a tetrahydrocannabinol concentration of no more than 0.3% of 1%, 0.3%, of the hemp-derived cannabidiol on a dry weight basis or in any finalized product.
So that's a total THC provision there.
Okay.
Which is weird because then they go on to say that any cannabinoid is prohibited. So I don't know why they bothered. And this is the thing about this bill, right? So they went so far. You know, like, have you ever been really like upset with somebody, like you break up with somebody and you just have like the revenge fantasies? It's like they were doing that. They were like, and then we're going to do this. And then we're going to do this other thing. And we're going to cut up all his clothes. And then we're going to set the car on fire. And then we'll put, we'll make all the flat tires and this is how this bill is. They were just like, and just throwing all this stuff in there. So they banned everything. And then.
Question. So it says that this section does not prohibit the continuous transportation through Arkansas, and it goes on to say from one licensed hemp producer in another state to a licensed hemp handler in another state.
Who's going to manage that?
Well, the question is why are they allowing interstate commerce? And I'm assuming that's because it's a federal rule.
Correct.
And they cannot go against
Correct.
interstate commerce because it's a federal
right.
issue.
So what they did was they did this bill to ban, and then they put a provision in there that said, but when we get sued, we'll have all these super strict requirements, and the requirements were meant to make sure that nobody could meet the requirements. So, for example, $10,000 for a license, you had to go through all these ridiculous hoops in order to get a license. If you had, I think it was like even a 1% change in ownership in the company, you had to refile all over again to get another, like they really, this is what I'm saying, they put a lot of thought into it's like a revenge fantasy.
What's interesting too is they're changing definitions.
Yes, they changed the definition of hemp. They sure did.
That's fascinating.
Well, I mean, just remember how many people I said voted for this, right? And so they all went along with it. Now, you could say that Arkansas is very conservative, but they have a medical marijuana program. So they're not that conservative.
How is their medical marijuana program compared to Texas's?
Oh, theirs is looser. They're making so much money. The companies are making so much money. And I only know this because I was in Arkansas a few months ago, and I spoke with somebody who has intimate knowledge of all the reporting back from the dispensaries and the marijuana companies, and he was like, they are making bank.
So it's essentially like a rec program.
Sure. Well, and it's another monopoly, right? So it's, one or two companies that have the licenses, and they also own the dispensaries. So, so of course they don't want anything else.
It's interesting. So they have the license fees here. So they're moving the wholesale hemp-derived products permit to $5,000, retail hemp permit to $5,000, manufacturer hemp product permit $5,000.
I just want you to think about Arkansas.
In Texas, by the way, those are $250 permits.
I know. Have you ever been to Arkansas?
I have, multiple times. I love Bentonville. Bentonville's beautiful.
It's a beautiful state, not super populated, right? Which means that the retail stores that have customers, asking them to pay a $5,000 fee is a lot for some of these guys, right? Because they're just small mom and pop stores or whatever. So again, a lot of thought went into this. And I will also say that we had a meeting with, after the lawsuit, we had a meeting with the governor's staff, kind of like, hey, can we just come to a compromise and make this thing go away? And they were like, no. So there is some incentive for them, right? I will say that the attorney who pushed for this from the governor's staff is young. He's like 26 maybe, and he's a teetotaler, and he wants everybody to be like him, which, that's where you get into problems, where you're not doing what's best for the state and its constituents, but you're executing the will of one person, right?
What's interesting is they have the Arkansas Tobacco Control in charge of it.
Mm-hmm. They have one guy, because Arkansas doesn't have a lot of people. They have one guy that's in charge of alcohol, tobacco, marijuana, any vice. This one guy is in charge of all of it. And he was super nice, because I met him too. Super nice. I think when I met him, he said, unlike so-and-so, which was the attorney guy, he said, I don't want to regulate you to death. He's like, I'm not trying to get rid of you guys. He's like, I'm used to dealing with the sin stuff. And I don't even know why it's considered a sin product, right?
Grows naturally.
I want to go to sleep. Is that a sin? I think no.
What's interesting, Arkansas Code concerning seizure, forfeiture, and disposition of tobacco products and other property is amended to read as follows. They add hemp into the tobacco control laws. That's really fascinating. So they're commingling hemp with tobacco to basically take the tobacco rules and put it onto the hemp. It's really fascinating how they did that.
Yes.
I haven't seen that before.
How many pages is there a bill?
17. 17 pages.
There's worse. I mean, Minnesota's bill was like 200 pages. It's just insanity.
Yeah, we'll have to talk about
Listen
that
to this.
someday.
The board may levy a civil penalty in an amount not to exceed $5,000 for each violation against a person found to be in violation of this subchapter, the Unfair Cigarette Sales Act, or the rules promulgated by Arkansas Tobacco Control. What does that have to do with hemp?
Nothing. One of the provisions in there that you're going to see is that they also banned any liquid, hydrocolloid, animal-based substance, thickener, sweetener, flavoring, synthetic product, propylene glycol, vegetable glycerin, or any other non-hemp derived substance is illegal. It's prohibited from being used in a hemp product.
So only what?
This is what I'm saying. It was like some kind of revenge thing where they were like, and what else can we throw? I mean, it's insane. It was so egregiously bad. So anyway, to go back to answer the question, which I'm taking a long time to do, we talked to our lobbyists, and he was like, I think you should talk to this attorney. And so Nicole Gillum, she was introduced to me, and so she and I started having a conversation. And she was like, I have a really good attorney, and his name is Abton, and I can never say his last name correctly. But it's you, Abton. You're the only Abton I know. But she was like, this guy has already sued the state successfully. She's like, let's talk to him. I spoke to Nicole and Abton about, and basically was like a preliminary conversation. And we started out with different law firms that, indicated they were interested in this kind of thing. We talked about budgets and who all might be interested. And so we kind of made calls to our colleagues and said, hey, can you help fund this lawsuit? And so we got 10 or, I think most people put in 10,000. We put in more, but I think most people put in 10,000. And so we kind of like came up with a game plan, and it was off to the races. And so we filed for an injunction. And this is the injunction. And I also want to say that there's an organization that pretends it's a hemp organization, but it's really a marijuana organization. And it's called...
That doesn't exist.
It's called ATACH. I don't know how you say it. Whatever.
We've mentioned them before.
Yeah. So those guys, unbidden by anyone, nobody asked them for it, filed an amicus brief in our case after we were awarded the injunction because they just couldn't keep out of it. It's not enough that they've wrecked the marijuana space. Then
That's the group that's run by a lobbyist, right?
Yeah.
Yep.
And then what does the amicus brief say?
Oh, their amicus brief says that everything we said is wrong, and we should not be granted the amicus brief.
It was pretty bad.
We should not be granted the injunction.
Bad in the sense of they didn't fully grasp the concept that we're arguing.
So we were told that it would take months, and so we filed in the 8th District Federal Court, and we were told it was going to take months before we get, a decision back or whatever. And the judge is like this 70-something-year-old farmer who was like, nope, this all sucks. And he turned around and granted the injunction in like 2 or 3 weeks.
I love it.
Kind of like when the appellate court came back in our case, in the Texas case, they told us it would be months and months and months, 3 weeks, and they had come back.
It's really interesting to see sort of the difference that the judges look at these cases and look at this industry versus how, a lot of the politicians or the marijuana industry look at it. And when the judges look at it from a legal perspective, almost in every instance, they tend to side with us because the laws are pretty clear. And if you're going at this based on the word of the law, it's pretty obvious that what we're doing is federally and state legal in almost every instance. And so, there are some states that can change their laws and do stuff to where it's not legal at that point. But for the most part, in sort of a general cursory look, hemp products are legal in most states unless they've changed their laws. They're federally legal. And the judges look at things from a perspective of, this is the law. What is the word of the law?
Yeah.
And in that case, in almost every instance, they've sided with us and said, you guys are correct in what you're doing and what you're saying.
And there's a line in here. We'll find it. But so the first thing was standing. Did we have standing to file this lawsuit, right? And so they held that we do have standing to do that. And also that we had the right to sue the governor, because that's who we sued, was the governor's office. And the judge said, yes, you, in this particular case, you can sue the government.
Because he's the one that signed off on it.
He's the one, she. It's Huckabee.
Really?
Mm-hmm. Yeah. So that was number one.
So we're suing governors now.
We are suing governors now. So that was the first thing. Did we have standing? Could we sue the governor? And because, it was the governor and the AG. And it was because the AG is the one that would be enforcing. So the governor's office and the AG. And the governor because she signed it. Okay. Then, standing. Sorry, meant to flip the page. Okay. So, preemption. That's the question, right? That was another issue for the injunction. Is there a question of preemption? Can a state do something that the federal government says not to do? And this gets super interesting. I might actually have to put my glasses on for this. But here, this one right here.
In analyzing the issue of preemption, the Supreme Court is highly deferential to state law in areas traditionally regulated by the states. First, federal law may preempt state law where Congress has expressly stated that it intends to prohibit state regulation in a particular area. Second, federal law may preempt state law where Congress has implicitly preempted state regulation by the occupation of a field. A field is occupied when the federal regulatory scheme is so pervasive as to make reasonable the inference that Congress left no room for the states to supplement it. Finally, even if Congress has not completely precluded the ability of states to regulate in a field, state regulations are preempted if they conflict with federal law.
And what do you think happened here? It conflicted with federal law because they changed the definition of hemp.
Yeah. That's fascinating.
Yeah, it's amazing. I think we won on like 4 different counts. Conflict preemption, blah, blah. And I'll let you read this one. So it put stuff back. It put hemp back on the controlled substances list, which
Correct.
no, it's been carved out. And you can...
Additionally, plaintiffs point to the fact that there is no distinction in the federal law between Delta-8 THC and Delta-9 THC, nor synthetic or non-synthetic hemp. Plaintiffs contend that Act 629 makes hemp production impossible and unconstitutionally places federally protected hemp back on the controlled substance list.
So this is what the Act provided for, and this is the federal definition. So basically... Arkansas.
They changed it to total THC when on the federal definition.
And they ended up somehow banning CBD entirely.
That's always fun. Why not, right?
Why not?
Get it all.
Unintended consequence or not?
Act 629's definition limits hemp to products with Delta-9 THC concentration that is a percentage concentration of a different cannabinoid, cannabidiol, which is absent from the 2018 Farm Bill's definition.
So, then we move on to all these derivatives that are fully allowed by the USDA's definition, which Congress approved. They take all these derivatives and say, nope, these are all prohibited.
It's half a page of them.
These are all prohibited. So Here, you read that part right there.
Under the 2018 Farm Bill standard, the only way to distinguish controlled marijuana from legal hemp is the delta-9 THC concentration level. Additionally, the definition extends beyond just the plant to all derivatives, extracts, and cannabinoids. The definition covers downstream products and substances if their delta-9 THC concentration does not exceed the statutory threshold.
So, in addition to deciding to change the definition of hemp, then they also double down by saying, and also all these other compounds that are found there are also prohibited. So again, in violation of the federal language. Okay. And so our pal, Mark Krause, the chemist.
Love you, Mark.
He testified, and do you want to read that?
Dr. Krause testified, for instance, that delta-8 THC is one of the many cannabinoids produced naturally by the cannabis plant, with no way to determine whether a product is derived from hemp or not. This indicates that the products are properly understood as a derivative, extract, or cannabinoid originating from the cannabis plant containing not more than 0.3% delta-9 THC. For everybody that, by the way, that argues that hemp and marijuana are different plants, this is pretty clear it's the same thing.
Well, that only applies to the marijuana people who somehow think they're superior. Whatever. Anyway, then he says, however, the Farm Bill's definition does not limit its application to method, derivatives, extracts, and cannabinoids that are produced. Instead, the definition covers all downstream products if they do not cross the 0.3 delta-9 THC threshold. Suck it. Federal Court, 8th District.
Boom.
Bam.
Now, after realizing some potential negative implications...
Wait, they're like, ruh-roh.
After realizing some potential negative implications with its participation, the Arkansas legislature has attempted to take a step back. Clearly, under the 2018 Farm Bill, Arkansas can regulate hemp production and even ban it outright if it is so inclined. The legislature seems to have tried to keep the parts of the program it likes, purely industrial uses, and eliminate the parts it doesn't, human consumption. That may very well be an acceptable distinction as it applies to the state's criminal code, but changing definitions in a federal program, which it has already fully joined, is not a constitutionally valid way to do it. Accordingly, plaintiffs have shown they are likely to succeed on their conflict preemption claim.
So they want to support industrial hemp, but they're screwing over the farmers at the same time.
This is it's similar to what was sort of done in Texas, but a little bit different.
How do you feel like it's similar?
Texas changed the law on a website and just created a bunch of words and made up a law. It's not that far different than what these guys did, although kudos to them for actually passing it legislatively. Texas didn't do that.
Overwhelmingly.
Yeah, I mean, they actually passed it through a legislative session, so kudos to that. At least
smaller
they
state, smaller legislature, smaller number of members. But what I find fascinating is that they all agree to stuff and then they don't like it. But rather than lean into it and go, okay, how do we make safety? Because that's what they all say. Oh, it's because it's a national, it was an emergency.
It was done in the context of an emergency.
Yeah. But instead of like riding the wave and realizing that, how long are you going to be stuck in reefer madness, the 1930s or whatever that all was? Or are you going to actually look out for your constituents and your businesses and put together a comprehensive, reasonable set of regulations, right? They just decide to go this whole other way, which is why, boys and girls, you have to be very careful who you vote for. Because if they don't reflect it doesn't matter if you like the party, it doesn't matter if you like the person. Do their policies reflect your policies? Then they talk about transportation, interstate transport. But they talk about how, so they did put in a provision, Arkansas, the legislature, did put in a provision that they would not prohibit interstate transport. And you brought it up earlier about from one licensed hemp holder to another one in another state. Number one, how do you manage that you know that? But the judge says,
continuous transportation is not defined or explained in Act 629 or elsewhere, which makes this attempt ineffective.
Which is another reason the injunction got granted, because they did not allow for that. Okay. So, do you want to read that?
However, the anti-preemption language defendants cite specifically references more stringent in-state regulation only as to the production of hemp, which means that Arkansas may continue to enforce laws regarding the growing of hemp within its borders, but not its interstate transportation. The 2018 Farm Bill clearly provides that states may not pass laws that interfere with the right to transport hemp in interstate commerce, including hemp derivatives like plaintiffs' products at issue here, that have been lawfully produced under a state or tribal plan or under a license issued by under the USDA plan. Arkansas law criminalizes hemp-derived products without an effective exemption for interstate commerce. For these reasons, plaintiffs have shown a likelihood of success on the merits of their claim that Act 629 is expressly preempted by the 2018 Farm Bill.
So essentially what he's saying is that despite the fact that they put a provision in there that says, oh, we're not prohibiting interstate commerce, they didn't tell you what would happen to, and they use, the judge uses a driver from Tennessee, somebody delivering a load from Tennessee, going through the state. Can they spend the night there and not be in violation of the law? And it's too vague. So that had to go out the window. The thing is, you know, when you try to regulate against every eventuality, you realize that you cannot. And you end up with a lot of dumb stuff like this.
Yeah, they made a lot of mistakes in this.
They made a lot of mistakes in this. So the injunction was granted.
Love it.
Arkansas is still operating under the injunction. We don't have a trial date. It's very possible that we'll go back to session before any of this is handled.
Yeah. Well, congratulations and thank you for doing this.
Congrats to all of us.
Thank you on behalf of the whole industry. I mean, this is something that, had it been allowed to stay, would have been a mess.
Oh my God.
And if other states started copying this, then you have to sue every
Can
state.
you imagine
it's just a train wreck.
The number of states that would have been like, well, Arkansas banned the whole thing.
Yeah.
Yeah. So.
Well done.
Yay us.
So this compared to AK Futures, which one do you see as more important, or?
Oh, this one.
Why is that?
If I remember correctly, AK Futures had to do with a trademark.
Right.
It had to do with a trademark. This is about changing language, preventing interstate commerce, injured parties, meaning, you know, you can't make any money, that kind of thing. So I think this one is way more important. Way more.
Thank you for joining us as always. Happy hunting, and we'll see you soon.
If we were a couple, I would have stabbed him in his sleep already.
Mm-hmm.
Yeah.
I'd be dead.